process work? If you die without a will, you have to start a probate proceeding.
Correct. Well, if you die with or without a will, you have to go through some form of probate proceeding in Texas. Now, if you die without a will, things become a little bit more complicated. So let's talk about that one because it's kind of what we're discussing in these videos. So let's say that you died without a will. The first thing, as we've kind of discussed, is your family has to wait for the death certificate to come in. Once your family has a copy of the death certificate, the state of Texas has another form which you can find online, which is called an affidavit of heirship. You'll have to fill out that as well. The affidavit of heirship is what the court uses to determine who the legal heirs are. Now, we talked earlier about how heirship works in Texas. So if you have a spouse, the spouse is one of the legal heirs. If you have children, the children will be legal heirs. If you do not have a spouse or children because you've died young or for whatever reason you didn't have a spouse or children, it will go up to your parents. If your parents have predeceased you, it will go out to siblings. So if you had brothers or sisters. And if things get a little more complicated than that, there's a handy-dandy chart that the state of Texas has in what's called the moiety system. It's a French design system from the 1700s. And it attempts to assure that there is some family member that they can find to give your products to. If they're unable to find anything, what happens is the process is called escheat, and that means that your estate will actually go to the state of Texas itself. But I assure you, the state of Texas does not want your estate, they do not want your money, and they will do everything that they can to find someone that can go ahead and be able to get your estate. Now, let's go back to that affidavit of heirship. So who can fill out the affidavit of heirship? So the affidavit of heirship must be filled out by someone who is not one of the legal heirs. So typically you'll have to find a family friend or someone that is aware of the goings on.
Family tree.
Yes, the family tree and the goings on with the family. And so what that person will do is they will fill out this legal document that says, you know, these are the spouse's dates of marriage. If there's a date of death for the spouse, they'll fill that in as well. They fill in the children, nieces and nephews, and on down. And once they fill that out, they'll have to go in front of a notary public and attest in front of a notary public. And so they'll sign and have a notary public sign that document because it's a legally binding document. You'll take that with your death certificate to the court, so to whatever courthouse it is where your loved one lived at the time of their death.
It's not a burden for the children, it's a burden for your friend. Your friend used to do all that.
Correct. So it's not just the children, also the poor family friend has to fill out the affidavit of heirship. So once you've got those two pieces of paper, you will take that to a local courthouse where your loved one has passed, and you will go ahead and file for probate proceedings at that courthouse. That's, again, going out of your way because you're having to go to the courthouse during business hours and be able to file all this paperwork. At the point that you started the proceeding with the court, you'll have to have a court hearing where you'll either need to be there, maybe depending on which county it is, you might be able to do the hearing via Zoom, but oftentimes you'll actually physically have to go during business hours in court. So you'll go in front of the judge will be named for the probate proceeding. Typically you're used to hearing who's the executor of the will. That means that you have a will. In this case, you don't have a will, so what the court does is it chooses a person that's called the administrator, because instead of having a will and having that sort of estate, they're administrating the estate. So the judge will choose someone to be the administrator. When they've chosen an administrator, remember earlier I talked about that 4% of the estate that would have to go somewhere?
The probate cost.
So part of that is they have to put forward a bond. And so the bond is just like if you went to jail, it's an amount of money that would cover if there were any miscarriage that's done by the administrator. So if you die intestate, the bond is mandatory. If you create your own will or if you use a living estate, or living trust or living estate, you are able to forego the bond and instead of costing that amount of money. But because you died intestate, you're gonna have to go ahead and put up that 4% for probate costs and for that bond.
So where does that 4% coming from? From the estate?
It comes from the estate itself. So one of the first things that the administrator has to do is what's called marshaling of the assets. It's a really complicated way of saying make a list of everything that the person owned. So the administrator has to go and find all those life insurance policies we were talking about, any vehicles, any assets or bank accounts that we talked about, anything that you have that's an asset. So do you have a business interest? Do you have vehicles? Do you have items that are collectible items?
That's not easy.
It's not
My
easy.
parents living in the other side of the world doesn't even know my assets in the United States.
Exactly. And my father was not a rich man. Okay, I'm gonna go forward and say that. However, he has an entire house full of stuff.
It could be complicated.
Yes,
the assets could be complicated.
He has an entire house full of stuff, a series of bank accounts, a series of life insurance policies. He may or may not own pieces of property in multiple counties. He owned at one point, and I've got to check.
Who knows?
I've got to check and see if he still owns them because we don't know. And he has an entire garage worth of very valuable antiques that we have to go through together as a family to try to find, which items are worth value, which aren't, and be able to make an accounting of those items. So the marshaling of the assets can take a significant amount of time, and it can be made complicated by the fact that because you died intestate, you don't have a list. Again, if you had a will or if you had a living trust, you would already have a list of those assets that were worth money, because either in the will or in the trust, you had chosen what's called specific devises. So you would specify which person specific items would go to. And sometimes those items are specific because they have great value, all right? So maybe you want a certain child to have this antique vehicle that you have, and it has good value to it. Sometimes those items are just silly items that have very little value aside from sentimental value. So, my childhood teddy bear doesn't matter to anyone else and would sell at a garage sale for 10 cents, but to me, it has a lot of intrinsic value and sentimental value. And so if it was at my parents' house, they may want me to have that. So because you died intestate, you have to go through everything and value everything out. And the reason that it's important to be able to marshal those assets, have that list, and provide those values for each one of those items is ultimately because you've died intestate, the court itself has to make a decision as to who gets what. It's not what the decedent actually wanted or the person that's died actually wanted. It's not what the individuals that are the heirs might have wanted. The court has to come up with a way to rightfully and equitably, to whatever percentage is owed, be able to split those assets and give them to the different heirs. So it becomes a much more complicated process, and it can be a very emotional process because it's possible that a certain loved one wanted a specific item, but because of the value of that item, they're not going to be able to get it because it doesn't fit in the proportion that they have been allotted because of where they are in the heirship. Whereas if you had a will or if you had a living trust, you could be able to give that item to that person using your specific device.
So if there's any chance that you can avoid this long process, and it could be very expensive too because the probate cost is 4%, you will take every single chance to try to avoid that and then create a peace for your family, right? To keep your family out of the conflict. And there's another thing about uncertainty. Is it possible that the judge will make a decision that is not your original will? Right? It's not your wish.
If you had a specific item that you wanted someone to have, the judge may have to make a decision that would not give that person that item. So for instance, if you had multiple homes and you specifically had stated, I want this person to inherit this one of the homes that I have, because that home is worth more than several other homes and it would be an unfair percentage to be able to give as a judge, the judge can state that either one, the home might be able to be liquidated and take the assets as money and be able to give a partial amount of money to that person, or the judge may state, oh, well, they're going to get this other home because it's worth the proper percentage. And that's not really what you wanted, and it's not really what the person that would inherit would want either. And you might even agree that the right thing would be to give them that house. But the judge's hands are tied in that they have to give a correct proportion. And that's going to make things very difficult, very frustrating, and a lot of times very emotional for the family members that are going through grief.
So if you want to avoid this uncertainty, you need to put your wish in the writing and then make it very clear and specific who is going to get what.
Correct.
And then also your kids don't need to deal with those arguments and an emotional process and the court process.
Yeah. And I mean, with my family right now, thankfully my siblings have been, we've been really civil with each other. We have a relatively good relationship. But we have been talking for like 1 to 3 hours a day over different things as far as funerary arrangements. Funerary arrangements, who's going to pay for property taxes, who's going to pay for utilities, how do we get the utility accounts themselves, who owns what changes can be made to the house that's a major part of my dad's estate. So it's really put us in a lot of ways, we're closer together than we ever have been because we have to make these decisions together, and that's something that we can kind of be thankful for. But in other ways, it does cause strain because we're having to make these decisions that can be very emotional and they may affect one or the other of us. And so it can be very frustrating, and it is adding a lot of stress onto all three of us to have to work together constantly to be able to make these almost minor decisions as well. To be able to make, make all the decisions that we need to be able to make to dispose of those assets.
I want to thank you so much for being here with us today and share your story, share what you have been through. We're really thankful that you want everyone to know what exactly going to happen if you die without will. So you maybe find this video useful. We'll be happy about that.
We handle estates in all 50 states. The other thing to think about if you're living in Texas, California, or the other 5 states that deal with community property, if you have a spouse that's living, community property can become very complicated very quickly as far as which assets were considered community assets versus separate assets as far as inheritance is concerned if you don't have a will. So if you live in California or Texas, definitely call an attorney.
So if you like our video, give us a thumbs up. If you want to know more about estate planning, subscribe our channel. We'll see you next time.